Court is now in session with your host, Peter Briggs.
Welcome to the Lawyers and Lay People podcast, a conversation-based podcast featuring interviews with some of Georgia's top lawyers, where we, in an easy-to-understand way, answer the questions that are on the minds of you, the layperson. In this podcast, we talk to specialists in a particular field of law to hear directly from them as to what clients typically ask them and what they should be asking. I'm your host, Peter Briggs. I graduated law school in 2006 from Georgia State University here in Atlanta and have been practicing as a lawyer for 17 years. I'm a personal injury and bankruptcy attorney as well as a registered mediator. I'm excited for our guest today. It's workers' compensation attorney Doug Kaleita. Doug received his undergraduate degree from the University of Florida. He attended Wake Forest University for law school. Doug has been a member of the State Bar of Georgia since 1990 and has been practicing as a solo practitioner since 1994, specializing in personal injury with a particular emphasis on representing injured workers and workers' compensation claims. He has been selected as a Georgia super lawyer for the last 2 years. Doug can be reached at KaleitaLawFirm.com. That's Kaleita lawfirm.com. Well, welcome to the podcast, Doug.
Well, thank you. It's a pleasure to be here.
Great. Well, I start off with all my guests in their particular field, and I always say, what is it you like about doing what you do? And I know you've been doing workers' comp pretty much exclusively for several decades, so you must like it pretty much. So what is it you like about workers' comp?
The opportunity to help people. You know, it's funny. I went to law school about 36 years ago, and the first day of law school, I had no idea what I wanted to do. The only thing I knew was I would never, ever do anything related to injury work because of the advertising lawyers that in my home state, Florida, were all over the TV and weren't very nice, and I didn't like that. And the first day of law school changed my mind entirely. I read a case about a woman hit by a bus in California with horrible injuries, and I realized I could use a law degree to help really badly injured people put their lives back together again, and that just lit me up. So the first day of law school, I did a 180-degree about face, and this is all I've ever wanted to do.
Well, it's a great way to fall into it. Some of us fall into it later, but you got to it quick there in law school. So what essentially is a prerequisite to a workers' compensation case? How do you know you have a viable case that is viable under the law?
Well, there's a couple of criteria for that. You must have an injury that arises out of and in the course of employment. So basically that means you need to be doing something you're supposed to be doing in a place where you're supposed to be doing it and suffer an injury while that happens.
Okay. So I noticed you just said the injury needs to be happening, during work. Well, does it matter how the injury occurred during the work? In other words, does someone else need to be at fault?
No, fault is actually supposed to be irrelevant under the Georgia Workers' Compensation Act. So all of this is statutory. All of workers' comp is found in the Georgia Workers' Compensation Act. And in that act, it says that you have to be engaged in an activity arising out of and in the course of, engaged in a work activity. So if you're doing personal things, sometimes that would preclude you from having a claim. But as long as you're doing something you're supposed to be doing associated with work in a place where you should be doing it, then you've got a claim.
Okay, so let's talk about at the onset when you have a claim, but let's just maybe take an injury that doesn't appear to be major, at least on the initial stages. What essentially are the pros and cons that the worker should be considering about starting a workers' comp claim, whether that's reporting it to their employer, starting treatment? What are some of the things they worry about as far as the system, and how does that kind of unfold?
That's actually an excellent question. And there are sometimes I tell people that they're probably better off not bringing a claim. If it's a minor injury and you like your job and you think you can get better quickly, it may be better not to bring a claim. If you've been working at the same employer for years and you get a great job and you get along with everybody real well and you think you're going to be better in a few weeks, it might be better not to make a claim. Workers' comp only pays for economic loss from loss of work and for medical treatment. So if you're not really going to be out very long, I'll tell people, let's stay in touch If you need me, I'll jump in, but you might be better off not doing that if it's just going to take a couple of weeks. So the more serious the injury is, the longer you're going to be out of work, the better you are with a workers' comp claim.
So with that person who it doesn't appear to be serious, but they are doing some treatment, are there any time deadlines they should be focused on, or how long, say, the injury just continues to linger that should sort of escalate it, gravitate them to reaching out to a lawyer like yourself?
Absolutely. There's two deadlines to be considered. The first is notice. It's always best to give your employer notice as quickly as possible to avoid problems later on. Like the closer in time to the point when you're injured, the employer knows, the less likely you are to have trouble bringing a claim if you need to, okay? But the outside limit is 30 days. You have 30 days to give notice to your employer. Best to do it in writing, but you don't have to, that you were injured. The second deadline to remember is that there's a 1-year statute of limitations if no benefits at all have been paid, okay? So if you say nothing and do nothing, but they did know about it within 30 days, you've got 1 year to file a claim. You must actually file a claim with the State Board of Workers' Compensation, which is the state entity in the state of Georgia that runs the whole workers' comp system. So one thing we want to remember that you didn't ask is that workers' comp claims are not lawsuits, and most people think they are. When you bring a workers' comp claim, what you're doing is making a claim through the State Board of Workers' Compensation. It is not a lawsuit. And hiring an attorney does not make it something different. It remains just a workers' comp claim.
So I know you threw out hey, you can tell your employer, report it within 30 days, but ideally it's in writing. Maybe it's not in writing. I'd imagine there may be some times where there's some sort of dispute, or the worker thinks the employer is giving them kind of a runaround. So what are some telltale signs that workers should be aware of where, maybe they are kind of getting the runaround from the employer and need to just reach out to an attorney to make sure everything's on the up and up?
Well, the first obviously is just being ignored, which happens more than you might think, or being put off. Hey, Bill, we know your back's hurt, but we got to get this job done this week. So just hang on. We'll get to this later on. Being put off, them telling them we're going to do something about this, but just hang on for a little while. Anything that indicates you're not being taken seriously. And if you need to go to the doctor and they refuse to allow you to, or they've refused to give you a choice of who to see or showed you a panel of physicians, anytime they're kind of schlepping you off, that's an indication that you probably ought to take care of your rights on your own. And that would involve a free consultation with someone like me who practices workers' comp exclusively for injured workers.
So now let's take a more significant injury where, they're more likely to reach out to an attorney. So if they have a pretty significant injury, what would be some of the risks outside of that 30-day and 1-year window, maybe in regards to which doctors they're being sent to or whatnot? What are some of the risks in delaying reaching out to an attorney like you when they've got a significant injury?
Well, delay in reaching out to an attorney. An attorney is not always necessary if the employer is doing the right thing. But the thing is, without knowledge, how do you know if the employer is doing the right thing? Right? I mean, there's a lot of rules around workers' comp. So in a more significant injury case, if they're sending you to a doctor who is kind of like giving you the runaround and not really taking you seriously, then you certainly want to be talking to somebody. Because what we want to remember is that the employer has the ability to control medical to some degree by having a posted panel, but those doctors are not always going to be particularly friendly to you. There's an old expression that everybody knows who butters their bread, and doctors make a lot of money from being sent workers' comp patients. So anytime you feel your doctor's not taking you seriously or not treating you properly is definitely the time to reach out for a free consultation with someone like me.
Okay. And so once a client signs up with you, what are some general rules that either you cover in the initial consultation or upon signing up that you want the client to follow?
Well, there's several of those. we don't want to go too far down the rabbit hole. We're kind of doing a general presentation here, but always be honest with the treating physician, any doctor you see, about everything. Don't exaggerate anything. And a lot of times it's a human nature for us to feel the need to be taken seriously. So we might tend to do a little bit of puffing when we're talking to a doctor, overestimate how much pain we're in or the severity of it. You want to avoid doing that because a good doctor is always going to take you seriously and view your injuries credibly. So perform an accurate history with the doctor. Give him an accurate history of how it happened, including on the job. You always want to point that out because all these things make their way into the doctor's records, right? And you want the other side to be able to see that. So always be honest with the doctors. Make sure you communicate with your lawyer about what happens at each appointment so that things don't get out of control without you having the appropriate help along the way. Generally, once you've hired a lawyer, it's better not to communicate with the adjuster anymore. And most adjusters know this. Allow your lawyer to do that for you so that you can focus on getting better. Right. Also, you want to make sure that you make it to all appointments. You don't want to be canceling appointments, or if you do, you need to have a good reason because that's a huge red flag. Right. Cooperate with physical therapy. Don't be canceling appointments there, and basically just follow the doctor's instructions, specifically with regard to work restrictions. Now, this is a big pitfall in workers' comp because everyone has a good day from time to time, right? And on a good day, you might be inclined to want to go mow the lawn because you can't afford a lawn service and it hasn't been mowed for a month and a half and the neighbors are starting to complain. Well, if the doctor has you on restrictions that won't let you do that, then don't do it. I often tell my clients that we will never know how often my clients have been placed under surveillance by a private investigative service because I only find out when they're caught doing something they're not supposed to be doing. Right? So in all those other cases, I'll never know. So we don't want to know there's a private investigator on your case because you don't want to be doing things that you're not allowed to do by the doctor's restrictions. It looks terrible, and we're going to have trouble with the insurance company as soon as that happens. So even on a good day, don't mow the lawn if the doctor says you can't do that.
Now, you touched, I believe, briefly earlier on the panel. Just explain a little bit. What are the workers' rights as far as which doctors they can see if they don't like the doctor they're with? What are the things they can do to maybe switch doctors, something like that?
Well, this is a pretty important topic, obviously. So let's take this from the top. Employers are supposed to have a panel of physicians posted in a prominent location on the premises where you work. Okay? So a posted panel, they all look the same. There's a form provided by the state of Georgia for this purpose by the State Board of Workers' Comp. And it will have the notice at the top in prominent letters. And then below that, there'll be some things about comp rules. At the bottom of that, it's usually 8.5 by 14, like we call it legal size, right? There should be 6 providers listed at a minimum. They're allowed to have, as far as the composition of the panel goes, they're allowed to have 2 what we call industrial clinics, which is not really defined under Georgia law, but it's a caduceus or a concentra or a emergency care or a doc-in-the-box kind of place, as we call it colloquially, right? Not like an orthopedist or a hospital. They're only allowed to have 2 of those. There has to be at least 1 orthopedic surgeon listed, and there has to be a total of 6, okay? So when there's an injury, the employer is supposed to show you the panel. It is supposed to be posted in a prominent location, like a bulletin board in a break room or a cafeteria, that kind of thing, or maybe the office that employees have access to. And they're supposed to show you that and allow you to choose from the panel who to go to. This almost never happens, okay? Georgia law is they have to have a panel posted. It has to be composed like that, and they need to give you a choice. Or the employer can suggest a physician for you to go to, and then that becomes your treating physician. So that is, as we call in our profession, a loophole large enough to drive a semi through, right? The employer is supposed to show you the panel and let you pick or suggest somebody. So what they do most of the time, not all employers, okay, but most of the time they say, oh, well, we use Concentra down the street, so you just go ahead over there. And the injured worker doesn't even know they have a choice. So if you're hurt on the job, you want to see a panel, right? So once you've selected from the panel, or if you've gone along with whoever they suggested, that becomes what we call the authorized treating physician, which we abbreviate to ATP, authorized treating physician. That doctor is then in the pilot seat. What he says goes as far as work status, as far as medical treatment. Whatever he wants, they are supposed to pay for. And a lot of times you'll need my help or someone like me, a comp attorney, to get them to do that. But that's what the law says. He's able to determine work status, hugely important. Are you able to work? Are you only able to work on light duty? Should you be out of work altogether? Right? So he's in charge of that, and that has great consequences for payment of benefits. Also, whatever medical treatment he prescribes, including referrals to other doctors, all has to be paid by the other side.
Okay. So, that covers a lot of the treatment component of it. Now let's transition a little bit to income. I'd imagine you have a lot of clients come to you and they say, I love my job. I don't want to lose my job. I also, I'm paycheck to paycheck. Income's very important to me, my normal income, full-time income. So how does it come about in your case, particularly, I guess, ones with more significant injuries, that you handle the potential changes to their income stream during their treatment? How does that work?
Another key question, if we could, let's back up one step. I think there's something more we need to add about the panel. If you are not satisfied with your choice or with whoever your employer sent you to from the panel, you have one free change to another doctor within the panel. And the other thing I want to add to that is, if there is no panel posted, then you are entitled to choose your own doctor. The insurance company is not going to tell you this, but it is the law. So to return to your question you just asked, income benefits. So income benefits in workers' comp are payable at the amount of 2/3 of your average weekly wage calculated over 3 months prior to the injury. Okay. So the all-important weekly check is 2/3 of your average weekly wage from a period of 3 months prior to the injury. And there is always a cap on that as far as amount. Right now, the cap, I believe, is $775 as of the most recent change per week. No more than that. And then there's also a cap of either 350 or 400 weeks on those benefits, depending on the nature of the injury and whether you ever get a full duty or light duty release or not. So with that said, these benefits are supposed to start at the point when the doctor says you are unable to work due to the injury and takes you out. Or if the doctor says you are able to do light duty work, but the employer does not have light duty work to offer you. Either way, benefits start at that point. You mentioned a more serious injury, which clearly is where we're more concerned about this. In the more serious injuries, that's usually going to be right away. God forbid if somebody's bleeding and they just broke their bones, it's pretty obvious they're not going to be back at work. There is a 3-week waiting period before benefits have to be paid. So even though you might be entitled to benefits as of the day after the injury because you just can't go back to work and everyone knows that, they have 3 weeks till they have to pay from the date of injury. A lot of times I can get the adjuster to pay that more quickly. If we've got a guy who's already had surgery and we're 10 days after the injury, I can usually get him to start benefits right away because it's obvious they're going to be out for more than 3 weeks, right? You have to be out for a total of 3 weeks for them to pay that first week. The first week is free until you've missed a period of 3 total weeks of work due to the injury. So from that point forward, checks arrive weekly. And there's lots of rules about how that's supposed to happen. But the bottom line is they're supposed to send you a check every week for a week of benefits at 2/3 your average weekly wage for as long as you are entitled to that until the doctor releases you to full duty or the doctor releases you to light duty and the employer can actually offer you light duty or until you settle the case or until either 350 or 400 weeks. Those are the 4 ways in which they come to an end.
So you mentioned settlement. Which are the kind of cases, just on average, I guess, that are easier to settle for a claimant? The ones that are less severe injuries or surgical cases, which tend to be more ripe for settlement?
Well, if ripe for settlement means you can get it done, clearly the more serious injuries. However, I think it's important to note that insurance companies like to settle claims, and you will frequently hear claims adjusters or even defense attorneys say the only good case is a closed case. The reason for that is any insurance carrier that writes workers' comp coverage in the state of Georgia is going to have more and more cases each month. So if they don't settle cases, they're going to have to hire more and more claim staff, and they can't possibly do that. So as a result of that, they love to settle cases. The cases that are always going to be relatively easy to settle are those cases where there was without question an injury. Everybody agrees there was an injury that happened on the job, and there has been medical treatment for that injury, and maybe there's also been payment of income benefits. Anytime those things are true, an injury on the job, payment of medical, payment of income, everybody agrees, that case can be settled whether it is serious or minor. Then it just becomes a matter of how big the settlement will be.
And how often do you wind up settling cases through the mediation process? Is that the majority of the settlements, the way they come about?
In my practice, mostly it is. You don't have to go to mediation. There's no such thing as mandatory mediation in a workers' comp claim. My professional take on this is I believe I can get more money out of the workers' comp carrier in a mediation than I can without one. Even though I pride myself on getting along very well with claims adjusters and defense attorneys, the involvement of a mediator, a third party there who is putting pressure on the other side to offer more money, I believe will usually result in a bigger settlement. So I always want my clients to go to mediation, especially in the larger cases. I don't think it's so important in a back strain case or a small comp claim that goes on for 2 to 6 months. Physical therapy, some treatment, everything's good then. You're able to go back or maybe not go back. Maybe you want to go to another job. The smaller claims, it's not necessarily needed. But anything that involves surgery or larger claims, I really prefer mediation because I think I can get more money out of the insurance carrier that way. And at that point, my job has switched. I often tell my clients that the first half of my representation consists of getting you the absolute best medical treatment I can to get you as close to normal as possible, right? Hopefully all the way. And then when that's happened, it shifts gears entirely. Now it's about getting you every single penny I can to settle that case. And I prefer mediation in larger claims because I've got some help through the mediator beating them up and helping me get them to a higher number.
Okay. So if the case settles, what exactly happens from there? Like, does a worker, their job essentially becomes terminated? Do they lose their health insurance benefits? What are some of the, immediate ramifications to them?
That is also an excellent question because most of the time, workers' comp cases, the more serious ones, do result in the employee either losing their job or having to resign. So in a settlement situation, the other side always insists on a resignation. This didn't used to be the case. In the 29 years I've been doing this, that wasn't the case back in the beginning. Nowadays it is, and that's mostly because of other legislation, most noteworthy being the ADA, the Americans with Disabilities Act. As a result of that, the employers are always going to want a resignation at the end, and they usually want a release too. So if you've been receiving benefits and you're going to settle your case, at the end, they're going to want a resignation. So you're going to have to leave the job. I have been able to negotiate exceptions to this in maybe 3 or 4 cases in the last 29 years. That's not a lot. And the reason is the insurance companies basically want to buy their piece. At the end of it, they want to be done. And rightly or wrongly, insurance companies consider someone who's had an injury on the job to be a risk going forward. And if they're going to pay to settle the case, they want to be off that risk. They want to go their separate ways. So the majority of cases end that way. For those that don't settle or for those that haven't settled yet, a lot of times the employer will just let the employee go. Now, people are always surprised to hear this, and I hate to be the guy who has to have the bad news, but the fact is in Georgia, it is perfectly legal to fire someone who was hurt on the job. That is not illegal. There's no such thing as wrongful discharge in the state of Georgia for an injured worker who's hurt on the job. They can let you go anytime they like. What they can't do is escape paying a workers' comp claim by firing you. But they can fire you the day after the claim, but they still have to pay the workers' comp claim. They can't get away from that, right? And so the rule of thumb I usually tell my folks is that the more serious the injury is, the longer it lasts, the more the insurance company pays, the longer you're out of work. As these expenses all begin to rise, the longer that goes on, the more likely you are to lose your job, either because the employer hires somebody else, or they just let you go, or they're angry because you even have a claim, which happens a lot. They're all worried their rates are going to go up, right? So the longer you're out, the more expensive it is, the more likely you are to lose your job.
And when you lose your job, I assume you usually lose your health insurance at that same time, or is there some period where you get to maintain it?
Well, when that happens, if the employer is subject to COBRA legislation, which everybody pretty much knows what that is, right? It's the ability to continue your health insurance you had through your employer, but pay for it yourself. So when they let you go, they will usually send you a COBRA notice. I have had cases before where they failed to do that, and we sued them in federal court for violating COBRA. But most of the time they get that right, right? Every employer knows they've got to do that. But it's important to know they are able to stop paying for your health insurance also. If they're going to fire you and if they're going to terminate your health insurance in ways that run afoul of COBRA, which is federal legislation, they have to give you a COBRA notice to let you pay it yourself, which is very expensive, and most people can't afford that, right? But again, being fired almost always results in a loss of group health, dental, disability, LTD, STD. All the benefits the employer provides generally are going to end if they fire you. It's just a matter of time.
And is the settlement money, is that considered income that is taxable to the worker?
It is not. There is an IRS code section on this specific point that all monies received for a personal injury or a workers' compensation injury are non-taxable. And because they're non-taxable at the federal level, they're also non-taxable by the state of Georgia. So it's tax-free. Now, you have to be careful about how settlements are worded at the end because sometimes they're trying to sneak in language that could make part of it taxable. But if your attorney's watching out for you, he'll make sure that doesn't happen. So generally the answer is they're not taxable.
So what happens to cases that go post-mediation, still haven't settled? How do they eventually tend to get resolved?
Well, there's two ways that can happen. It could always settle later, right? Mediation is not your last chance to settle. And of course, you've experienced this in your practice where you go to mediation and they're just not taking it seriously. I like to say they brought a knife to a gunfight and they're just not willing to pay enough. Then you just continue on with the case as normal. In workers' compensation, that means that they will continue to pay income benefits as they're due week by week. They'll continue to pay for all medical care that is reasonable and necessary to treat the work injury, right? And later, maybe they'll pay enough. I've had this happen before where we go to settlement, mediation, and they just don't bring enough. You can always settle it later. Sometimes it happens 2 days later. Sometimes it's a week later. Sometimes it's 3 months or even a year later. So you can always still settle the case. If the case won't settle, and it's important to keep in mind that neither side can force the other one to settle, right? The employer can't just ram this down your throat and make you take what they're willing to offer. You can just say, no, I'm not going to settle, right? And likewise, we can't force them to pay more than they're willing to pay in most cases. So in cases that don't settle, it just continues on until the categories of benefits are paid out under Georgia workers' comp law, which would be your weekly benefits. For medical treatment, it's important to note there is a 400-week cap on medical benefits. So you've got 400 weeks from the date of injury to treat for any injury that is not considered catastrophic. So basically, that's most of your workers' comp claims. There's medical treatment available only to 400 weeks, right? So the categories will just kind of expire naturally. They'll get to the ceiling on weekly benefits. Then they'll pay out your PPD rating, which we haven't discussed yet on camera. They'll pay out your 400 weeks of medical benefits, and then basically the case is over and there isn't really anything much left to settle.
But 400 weeks is basically 8 years. So that is essentially the hook to that presumably they'll offer a reasonable settlement at some point.
Usually they'll do that. And frankly, and remember our conversation earlier that they want to close files. You know, the only good file is a closed file to them. So they do like to close files. So most cases do settle. Thankfully, because that's mostly how I get paid. We haven't discussed that either, but workers' comp attorneys are paid as 25% attorney's fees of any settlement that they procure for you. So at the end of the case is when I usually get paid. 25% of a settlement we reach at the end. Now, there's another way to get paid, which is if the attorney is responsible for collecting benefits that they're not paying, and it's his efforts that get them collected, then he can receive 25% of those as well. So those are the two ways an attorney can get paid. 25% of benefits that he is literally responsible for collecting. It has to be his efforts that got it. They weren't doing it otherwise. Or 25% of a settlement at the end. So basically, you don't have to pay your attorney anything yourself.
Right. It's a contingency fee, basically.
Right,
so
like
you don't have to
cases.
come out of pocket. And I guess with them all being consistent at 25%, I guess when you're attorney shopping, at least that element is sort of a non-factor, shopping which attorney is going to charge a different rate.
Right. It's all uniform throughout the state of Florida, and all of us have just about the same contract. This is all closely regulated by the State Board of Workers' Compensation. Every attorney fee agreement, which is our contract, all of them across the state of Georgia are required to have language in there about this very thing, that any fee greater than $100 must be approved by the State Board of Workers' Compensation. So you can trust that any attorney who knows assault and workers' comp is going to have the same contract, the same agreement, the same fees. Those are also regulated by statute to 25%, no more.
So with the fees always being the same, just for a layperson picking an attorney, how do you what are the things you think the general person should be looking for in an attorney? Is it just the rapport, how you get along with the attorney and the client, or are there some other factors that you think when they're Googling for workers' compensation attorney that they need to keep in mind?
Well, clearly experience is a huge factor, right? And there are some guys, like in smaller towns in particular, there's a lot of really good lawyers in smaller towns, and there may not be enough workers' comp in the area, so they kind of do 3 or 4 or 5 different areas. For a typical small workers' comp case, that might be fine. For one with more complicated injuries, you may want someone who specializes. The more serious the injury, the better off you're going to be with someone who specializes. So experience is key. How long have they been doing this? How well known are they in the community? Do they have the respect of the judges and of the insurance companies and the defense attorneys? Do they know doctors? Do they have a good familiarity with the panel doctors, for example? Like if you've got a copy of the panel, which you should always try to get, even if it's just taking a picture of the bulletin board where it's posted, you always want to get a picture of that if you can, right? So does your attorney know those doctors on the panel? If he does, that's a pretty good sign that he knows what he's doing. Also, you want someone who's going to explain the categories of benefits to you. And I routinely find that a lot of attorneys don't do this. There are some occasions when someone will let another attorney go and they'll come to me. Routinely, when that happens, I find that the other law firm did not explain the categories of benefits, which to me, how are you doing your job if you don't do that? People call us so they can have information. It's all about information and help. So you want someone who's going to explain what workers' comp pays and also what workers' comp does not pay. For example, pain and suffering. That's not available in workers' comp. Well, your attorney needs to explain these things to you early on. And he should be able to answer any questions that you have about the system, about the benefits, about provision of medical care. And you mentioned rapport. Everybody knows whether they're getting along with somebody or not, and everybody can get a pretty good sense of whether this guy's more about the money or he's more about helping the injured worker put their lives together again. And you certainly want the latter.
Now, I know in that previous answer you mentioned pain and suffering. So essentially, that's a big difference in a comp case versus a personal injury case. Essentially, comp, you're taking out the negligence component, and then the downside or the trade-off, I guess, is you're not really getting the pain and suffering component that you would get in a personal injury case. So maybe give a real-life example. Let's just say you're on the job, your coworker's driving a vehicle, and you two get into an accident. Explain essentially how your claim can be different or how you can have more claims if, say, the person at fault for the car accident while you were on the job was not your coworker, whereas how it would change if it was your coworker who caused the accident.
So the very key distinction there is if it's your coworker, you would have a workers' compensation claim because it happened on the job, right? But you would not be able to bring a personal injury claim against your coworker. In your other example, you're on the job, maybe you're driving yourself or somebody else causes an accident who's not got anything to do with your employer, just another car on the roadway. Well, you have a workers' compensation claim still because it did happen on the job, but now you have what we lawyers call a third-party claim, a personal injury claim against the other driver because he's not associated with your employer. So the key thing we want to remember here is under what we call the exclusive remedy doctrine, if you have a workers' comp claim, you have no right to sue your employer, even if your employer is negligent in causing the wreck. And this or causing the injury of any kind, like they may have failed to maintain a piece of equipment properly, or they may have disabled a safety guard. Okay?
Right.
You do not have a claim against your employer for personal injury or for negligence, even if they were negligent. You still have a workers' comp claim. Okay? But if somebody else took the guard off, right? Like let's say you work in a chicken plant and they had one of their vendors come in and remove a safety guard from a piece of equipment and you're injured because of that. Well, you've got a workers' comp claim against your employer. I don't mean to pick on chicken plants. This could happen anywhere, right? You've still got a workers' comp claim against them, but because somebody else besides your employer was modifying the equipment, then you've got a personal injury claim against that somebody else. So coworkers and your employer are always protected from suit for simple negligence in a workers' comp claim, right? But other parties are not. So there are many times where you do have both a workers' comp claim and a personal injury claim, just not where somebody in your employer was negligent. Then you got only a comp claim. And of course, as you pointed out, then there is no recovery for pain and suffering, which I think, frankly, your attorney ought to be telling you in the very first conversation. So you're not at the night before mediation talking about your pain and suffering. If that happens, your attorney hasn't done your job. So you want to have someone who's going to explain this to you straight away. For me, it's the first conversation.
So, and you did mention earlier judges, and explaining the workers' comp case, I guess, when you're in front of the judge, how a hearing goes, just how does that process work out? Because it's not a lawsuit, as you said.
Correct. And it's really important to remember that. A lot of people call me and they're afraid to pursue a comp claim because they think that getting me involved turns it into something it isn't. And that's not true. The moment you get injured on the job, you have a workers' comp claim. The question is simply, do you need or want help with that from me or another qualified practitioner, right? So most cases, fortunately, don't really go to a hearing anymore. And that hearing is available at the end if there's something that cannot be agreed on, or if the employer just will not agree to pick up the injury, or if their workers' comp carrier will not agree to pick up the injury, right? Then you do wind up at a hearing. Most of the time that doesn't happen though. But if it does, it's a litigation process, which involves various exchange of documents and information, as we call them, interrogatories and requests for production. And then they will take your deposition. The other side will take your deposition in front of a court reporter. Nowadays, mostly in the post-pandemic world, that takes place via Zoom, which is very convenient. And then after that, usually somewhere along the way, the case will resolve. If it doesn't, you'll wind up in front of a judge for an evidentiary hearing. So that's a fancy word for you go tell your story to a judge in a courtroom. Those are often also handled by Zoom nowadays, which is rather nice for our profession. So at a hearing, your attorney will have you present your testimony via questions on a witness stand or via Zoom, right? And then any other witnesses on your side, like if you're trying to prove the injury really happened, you might bring along Joe and Sarah who saw it happen. Right. And then the other side will present their evidence. Of course, it's like a regular trial in that you can be direct examined and cross-examined. You speak with your attorney asking questions, then the other side, their attorney will ask you questions. We've all seen this on Perry Mason and Boston Legal and all those kinds of shows where everything's
different in real life.
It is different. It's quite a bit different in real life. For one thing, our careers are not quite as exciting as William Shatner's is, right? And I think it's Boston Legal. But
we also don't wrap up our cases in an hour.
Unfortunately not. Yeah, we don't get the case of the century. We don't get to finish it in 45 minutes plus commercial breaks.
So before I let you go, I did want to just get you to run down the kind of classifications, I'm probably saying this wrong, of injury? You mentioned PPD. Like, what are the essential, I think you threw out catastrophic injury at one point. What are the different kind of designations of your injury that you can have?
Well, as far as designations go, Peter, it's really non-catastrophic versus catastrophic. All categories are available in both claims. So if we're to draw categories for basically someone who doesn't really understand this and is trying to get something out of this, you would say the first kind is the medical only, where it's just a medical case and maybe like a back strain or a ankle sprain or something. And, a secretary doesn't need to walk around a lot, or a receptionist, so she can still work. So the first category is medical only. There's no lost time. Those don't usually go on very long, and they just pay your medical benefits as they come due. In other words, they pay your doctors, physical therapy, whatever. And then either you just stay at the employer. In medical only, it's very common to be able to stay at the employer because you've been working the whole time. And if they like you, there really isn't much reason to settle that. You're not going to get a lot of money. You're probably better off keeping your job, right? So the first category would be medical only. The second category would be one where you do miss time from work, which they're going to call a lost time claim for the obvious reason. And those settle more often. This is a case where, again, it could be a sprain, but instead of being a secretary or a receptionist, you're a cable installer. Cable installers not going to, and I've had cases like this where you're not going to be able to install cable with a sprained ankle. So now you've got medical and lost time. Now you're getting to the point where this case may likely settle, right? And again, the longer you're out, the more likely it is to settle. But this is the case where you're going to get better, right? It's medical and lost time, but you're going to get better at the end. You're probably going to settle it. Then you've got the cases where you're just really not going to be able to go back to work. If you're in one of those and you get a light duty release, but there really just isn't anything the employer can give you, like you work in a steel plant or a welding facility, and they just don't have light duty work there, but you can't do anything there, but you still have a light duty release, you could do other things. Those cases are going to go on for quite a while. The longest they can last is 350 weeks. Okay, so again, this is a case where the injury is more serious. The employer can't put you to work. That's probably going to settle somewhere along the way. If not, it goes out to 350 weeks unless they find you a job earlier, which they can do. And then you've got the more serious case where you never get a light duty release at all. And I have cases like this where they've been kept out of work literally for almost 8 years, 400 weeks, and then the benefits stop at that point. Right? That's the kind of our third category there. Any case that involves that, you've got to look at whether it's now going to be our fourth category, which is catastrophic. And catastrophic, let's throw this out there while we still have a moment. There is a claim for catastrophic injury in the state of Georgia. It's just what it sounds like. A severed limb. You've lost your leg. You've lost your arm. There are other certain specified categories. Burns over a certain percentage of your body is another one. There are enumerated categories that are automatically considered catastrophic. And then there's what we call a G6 catastrophic claim. And that's the same exact standard as Social Security disability benefits. It's complicated, but I'll just put it out there. There are no jobs available in reasonable numbers in the national economy for which you are otherwise qualified. Same as Social Security. If you meet that standard, and in any case where you've gotten to 400 weeks and you're still not released, your attorney really needs to be looking at whether you meet that standard or not. Because usually by then you will have settled or gone to work, right? So if you've gotten to that point, you may have a catastrophic injury, and if you can prove that, or if the other side agrees, then you've now broken the ceilings. There's no ceiling of 400 weeks on medical treatment. There's no ceiling of 400 weeks on income benefits. They are available for life in that type of case. Catastrophic claim. So that's our fourth category, right? Medical only, more minor injury, missed time, more serious injury, missed time, catastrophic beyond 400 weeks.
Well, I think we've come to the end here. I want to thank our guest, Doug Kaleita of Kaleita Law Firm, for joining us on this podcast, and to thank you for listening. You can find Doug at KaleitaLawFirm.com. That's KaleitaLawFirm.com. lawfirm.com. You can visit me online at brickslaw.com. That's BRICKSLAW.com. You can also rate or review us wherever you get your podcasts, Apple Podcasts, Stitcher, Spotify, Google Play, or wherever. All of our contact information can be found in the link below. For more details, please email me directly at peter@brickslaw.com.